Okay, welcome back. This is Philip Bickle of Legal Tyranny, and this is still the argument section of an appeal I filed. So we're going to continue working our way through this on June 24th, 2021. Okay. Mr. Bickle. Okay, and then one other clarification is, which oral recitation of the charges were you relying on to make the determination of Rule 7 that Rule 7 had been satisfied, that the citation and the oral recitation had been committed? The court. The oral charges that I'm going to use were the ones that you were orally charged with right at the beginning of the trial. I have repeatedly raised these issues with the district court, only to be ignored. Hence, proceedings have dragged on for years, as I was never charged within a statute of limitations. How is one supposed to make an informed plea or prepare a defense when one has never been charged? All right, that's a key point right there. That whole issue of what is the nature and cause that you're up against. They don't fill you in at any point. If they don't give you specifics, you can never prepare a reasonable defense. Okay, so this is Part C in the argument section. The first trial court judge, Harry Freitas, erred in conducting and establishing a prima facie case, and by not finding that, as a matter of law, the prosecution had failed to comply with the requirements of process for initiating a criminal case that caused harmful effects and injustice to defendant-appellant. The record on appeals shows that as of the December 15, 2017 hearing with Judge Freitas, there had been no charges filed in a verified complaint by a licensed prosecuting attorney. Only a traffic citation had been filed by the police officer Clarence Davies III, who does not hold a license to practice law and who is not a prosecuting officer. Even if this citation could somehow be considered as charging me with violating the law, the alleged charges did not state all of the elements of an offense, such as, but not limited to, intention, and they were not given in plain, ordinary language which anyone can comprehend. I could not prepare a proper defense or plead double jeopardy at a later point with such a vague document as a citation which Officer Davies III gave to me. Okay, this issue right here, of plain ordinary language, that's the common vernacular. And just look up the word vernacular, V-E-R-N-U L-A-C-U-L-A-R. I think that's right. And that's the common term that you'll find when referring to this issue. And the main issue right here is you're eliminating their ability to use legal terms of art or legal definitions. You're requiring that they give it to you. So whatever they've got set up as a legal term that may encompass certain context, they have to spell out those contexts. That's a requirement. Otherwise, they're leaving out the context, and us being the lay people, not trained in law, we're not going to know that, hey, this thing may have context, like the word jurisdiction. You might see in one of my other videos, let's see, which might have even been the trial, the judge kind of played around with the word jurisdiction a little bit, like, oh, well, he was saying certain things, and that wasn't, he knew that wasn't the context that I had just used the word jurisdiction in, and I had to correct him and clarify and make sure that it was clear on the record that I wasn't using what he had just proposed, because that would eliminate my argument. All right, let's focus on this. Okay, and this. I've seen case law that allows somebody to get an appeal overturned if they're not able to plead double jeopardy as a result of failing to provide them with clear and concise charges that can't be, applied again later because the first time they were vague, and then, they turn around and they try to hit you with it again, but maybe change the wording. So that's a big one. Double jeopardy isn't as important, in my opinion, as due process, because due process actually incorporates like everything under it. If absolutely nothing that you're doing is being done in a fair and neutral manner, then it just blankets everything. And unfortunately, they wouldn't hear one of my other appeals based on due process violations, which is disgusting. But I mean, it just shows the state of things with these courts. I'll have to do a video on that one, because that one in particular really just, most people just really, okay, so there are some that may still sit on the fence on the whether or not courts are going to solve certain issues. They're not going to solve anything for you people. They work for a different class of persons, and you're not included in that class. So go watch some George Carlin and get that the simple concept sunk in. Like, we got to stick together. They're sticking together. We got to stick together. Okay, so this is citing several sections of case law. I'm going to go ahead and read it. I'll read it for you all. Resolution of the question of whether the information at issue is sufficient to satisfy the prescriptions of the Due Process Clause of the 14th Amendment must begin with an analysis of what is required in order for a charging document to meet the precepts of fundamental fairness upon which the Due Process Clause is bottomed. The requirement that any charging instrument or any charging document must furnish a defendant with a sufficient description of the charge against him has long been recognized to serve a dual function, namely, 1. To enable the defendant to adequately prepare his defense, and 2. To enable him to plead double jeopardy against a second prosecution. It is the former of these functions with which resolution as to the sufficiency of the charging instrument at issue lies, and upon which the decision of the Federal District Court, which we are asked to review, was founded. Accusation must sufficiently allege all essential elements of offense charged, whether accusation is oral charge, information, and indictment, or complaint. Okay. Now, they're trying to claim that the cop citation is a complaint, but again, they're required to make an oral charge in conjunction with those tickets from the cops. And so when they make that oral charge, they have to have all of the essential elements present. That's jurisdiction claims, that's every element of the offense. Let's see here. Okay, because the complaint failed to state a material element of the DUI that the prosecution was required to prove, it failed to state an offense and, therefore, was fatally defective. Accordingly, the district court lacked subject matter jurisdiction to preside over the prosecution's DUI case against Cummings. That being so, 1. The district court erred in denying Cummings' motion to dismiss the charge based on the defective complaint, and 2. The amendment of the complaint after the presentation of the prosecution's case-in-chief failed to remedy the problem, inasmuch as the prosecution's case-in-chief, absent a proper complaint, was a nullity, and the amended complaint could not confer jurisdiction retroactively. On September 25th, 2012, Crilley's counsel appeared and claimed that Crilley was not properly served because only a copy of the summons without a copy of the complaint was served. The notice of entry of judgment and or order and plea judgment filed on September 25th, 2012 reflects that. No action taken by court until proper service made. The complaint and summons were served on Crilley October 31st, 2012. At no point in time before the December 15, 2016 hearing was I served with a complaint stating charges by an authorized licensed prosecuting attorney on behalf of the state of Hawaii, accompanied by a summons issued by a clerk of the trial court. In addition, the ROA does not show that the prosecution ever filed a proof of service of complaint with a summons issued by the court clerk. See Hawaii Rules of Penal Procedure, Rule 9A1 and Rule 9B2. Now, this stuff right here is extraordinarily important. Every single time that you see me citing something, look it up. This is what you need to know to be able to go in there and make judges think twice about moving against you and how they're going to look in the public's eye. But know the rules, like study it, understand it, and make sure that if they cross-reference and go to any other rules, you go and look those up too, because sometimes rules reference other rules. It's just like their legal terms of art. Sometimes they actually have other legal terms of art within legal terms of art. The record on appeal reflects these facts. The official transcripts for the December 15, 2016 hearing included with this appeal show that there was no oral recitation of the essential facts constituting any of the alleged offenses by the prosecuting attorney for the state, Evan Smith. See Hawaii Rules of Penal Procedure, Rule 7A. Now this state prosecutor right here is now off teaching constitutional law, which is another dark ironies, one of the dark ironies out there. And we're concerned with corruption and everything else, and we have this guy that didn't even enter charges against me, and he couldn't comprehend or didn't want to acknowledge. I mean, none of them want to admit it that they weren't following the rules and statutes there. The judge helped this guy out. This guy just stood mute after I started calling him out on certain things. He just stood mute and let the judge deal with it. So, that's what we're dealing with right now. These people that are teaching either don't know or they know and are corrupt. So it's one or the other. And in either case, they shouldn't be teaching. There should have been no action taken by the trial court to create a case or to hold any hearings, especially after it was pointed out at the first hearing on December 15, 2016, that the above had not occurred to confer jurisdiction upon the court. That's a requirement. They have to have charges, a case brought before them, and the charges have to be entered. So that confers subject matter jurisdiction when charges are entered. All of these issues were also raised in my motion to dismiss for lack of all jurisdiction. There were no valid charges against me and no proof of service of a summons, and Judge Freitas should not have ordered me to appear after the December 15, 2016 hearing, and he should not have required that I file a written motion to dismiss when the foundational pleadings for initiating a case against me had not even been filed. I think off the top of my head in Hawaii it's Rule 12 that indicates a judge may enter a plea for you if you're refusing to plea, and in that same section it indicates that the very first thing that must occur is that a pleading is filed by the prosecuting officer. And at that point in time, once that's in, everything's set right for you to be in a position to have to enter a plea. Now, if the charges or anything else is insufficient, that's where your demurs come up, or in Hawaii's case where they've abolished that, a motion to dismiss, raising those issues. Google a demur, Demurrer, and look into that. They still use them in states like California, and I think they're pretty common actually. Okay. Alright, so yeah, that's going to be it for this section. If you liked this section, please like, subscribe, share it. Share this as widely as you can. YouTube is not really making these much of an important thing in the algorithm, even though tons of people are doing searches on, how to beat a traffic ticket. And here I am. I've got, a bunch of wins under my belt, and I've put a lot of info out there for people, a lot of info, but I don't get a lot of traffic because YouTube isn't helping. So you guys have to help. If you can't make a general donation for research or the stuff that I'm doing, then just help me out by sharing. All right, until next time.